let's bring back in civil attorney and former prosecutor Kirk Davis. So we were just discussing earlier, this defense team clearly has a well-organized plan. But our jurors, and I don't know if you know about West Virginia in particular, are they more inclined, though, to just kind of believe the prosecutors?
Oh, that's a great question, Joy. I think that you've got kind of two countervailing forces there, right? I mean, maybe you've got some jurors there who are inclined towards law enforcement and hence the prosecution. But this is America, and the right of self-defense runs strong and deep and old, and people are going to find that compelling. I think when there's an issue of self-defense raised, because the jurors are going to say to themselves, I want that right as well. I want to be able to defend myself, and I don't want to find myself in this situation charged with a crime like Mr. Lilly if I'm defending myself. So I think it could go either way on that one.
But here's the thing, that this victim was found laying in his own yard in a pool of blood. So, of course, we hear a lot about the success of a self-defense argument if you're in your home is your castle, but it's the victim's home.
Well, fair point. But in listening to the defense argument, it sounds like that there's a trail of blood, and the argument is that this did not occur in the victim's home. It occurred outside the home, out in the street area, and so. You're right. I mean, it would sound reversed if this occurs in the home of the victim. Then your home is your domain, and you don't want anybody coming in there and messing with you for sure. But if it occurs out in the street and indeed this knife does belong to the victim, then that's a hard one for the government to explain.
Yeah. So, we talked a little bit about what you think that the state really needs to do here. Do you think that there's a problem with this testimony that we're anticipating about the neighbor?
Sure sounds like it. I mean, if what the defense is saying is accurate, and that this neighbor has only met the defendant, Mr. Lilly, a couple times, or only heard his voice a couple times, boy, that is certainly not enough for beyond a reasonable doubt. Now, of course, that's not an element of the charge, right? Just hearing a voice, but that has got to be one of the key pieces of the government's evidence, is that this voice is the defendant. This voice saying, "I'm gonna kill you."
Yeah.
I mean, if you got that, that's tough.
Yeah, and I believe that witness to be LaDonna Reed, who was a next-door neighbor and apparently found the victim's body some 20 minutes after, and then called 911. Yes, I understand the defense taking issue with that, but at the same time, if this is a witness who was there 20 minutes after calling 911 right away, isn't that pretty strong for the state?
I don't think so, because you're gonna, again, and if she is not able to recognize that voice with strong confidence, I mean, she's gonna, if she gets up and says, "I've heard Mr. Lilly before, I know him, and that's him," then that would be something. But if not, no.
All right, well, we are going to have to see what happens. And thank you so much for joining us, Kirk. We have much more ahead on the trial of Nathaniel.